Welcome everybody and thank you for being here. We're about to spend the next 40 or so minutes walking through what every Texas family needs to know about wills, trusts, and protecting what they worked so hard to build. We're going to give just another minute to let everyone else get logged in, but while we do, let me share a little bit about what you can expect. So what you're going to learn are real options that you have when it comes to estate planning, and just as importantly, what can happen when the wrong plan is chosen or when no plan is in place at all. I'm going to walk you through real situations with real families and real outcomes from cases that I've really handled. And as you hear these, my goal is simple, that you start to see where these situations could apply to your own family so that you can better understand the risks, the potential costs of inaction, and what's really actually at stake. Then at the end, if you decide you want to avoid those kind of bad outcomes, I'll walk you through what it looks like to work with us and how to take the next steps if you want to do so. As we go, feel free to use the chat box that's on your screen to ask any questions, and we'll try to get those addressed along the way, or we can email you later. All right, let's go ahead and get started. What would happen to your family tomorrow if you didn't come home tonight? Not 5 years from now, not someday, tomorrow. Would your kids know what to do? Would your spouse have access to the money? Or would your family be stuck, confused, stressed, and waiting on courts and paperwork while they're trying to grieve? Welcome everyone, and thank you for taking the time to join me today. My name is Jason English. I'm an estate planning attorney here in Austin, and for more than 25 years, since 2001, I've helped families plan ahead. And just as importantly, I've helped families clean up when planning didn't happen correctly. And it's that second part that's actually shaped how I approach estate planning today. And because when you spend years working with families after someone dies, you start to see some patterns. You see that the same mistakes repeat over and over again. I'm talking about good people, responsible people, people who intend to do the right thing. I'm talking about you, people that met with a lawyer, watched some estate planning webinars, but their family still ended up dealing with court proceedings, legal expenses, and sometimes even family conflict that, well, it could have been avoided with better planning. And today, what I want to do is talk you through what actually happens in the real world when someone dies. We're going to talk about wills, trusts, probate, the three main ways that families typically plan ahead. By the end of the presentation, our goal is simple. We want you to have clarity so that you can look at your own situation and say, okay, now I understand what my options are. Before we begin, let me set some expectations for what the presentation is and what it's not. It's designed to be educational. It's not a sales presentation. There's no paperwork for you to sign. And obviously, we're not giving legal advice to specific situations during this webinar. We do want you to be more informed about estate planning because some of the biggest problems that people face with estate planning is they don't even know what questions to ask. Some of you watching may already have a plan in place. You may have signed documents years ago, but you aren't really sure if they work anymore. But some of you probably haven't done anything, and that's very common. So we'll tell you that roughly 70% of Americans have no plan in place. And so if that's you, you're far from alone. Why is that? Well, estate planning, we know it's very important, but it's almost never urgent. Only after we have a diagnosis, or a death, or maybe an accident, but then it may be too late. We're hoping by the end that you should have a clear understanding of what estate planning strategies exist, how they work, and then decide what actually makes sense for you. And we hope that you have clarity about your options as well as clarity about the risks. I want to tell you a little bit about my background. I grew up in a family full of lawyers, and I grew up around estate planning. My father was an attorney, and as a kid, I spent time in his office seeing how documents were drafted, how estates were handled after someone passed away. And then when I started working as a lawyer, I worked with my dad. And he had me writing wills, he had me probating wills, building out comprehensive estate plans for clients. And at some point he said, you really need to go to the DA's office and have him train you, get trial experience, and then leave. And so I took my dad's advice, and I spent years working as a prosecutor. And that courtroom experience turned out to be incredibly valuable. It's also important that I tell you that one of the two probate judges that we have in Travis County was also a prosecutor. He was my coworker and colleague at the DA's office. And what my dad was really trying to tell me was that a lot of people in the estate planning field, well, they've never worked in litigation, so they don't see how the documents that they're drafting get ripped apart. In that experience, well, it helps my clients plan in a better way, plan to protect their loved ones and themselves,
Because the courtroom, well, that's where you see what happens when things break down and you see how things get resolved. You see the situations where someone thought everything was taken care of and it absolutely was not. And those experiences, well, they shape how we approach estate planning. The goal of a good estate plan is not simply to produce documents. The goal is to produce a plan that actually works when your family needs it the most. This presentation, it's really designed for three types of people. The first group are the people who already have a plan. So maybe you signed documents 5 years ago, maybe 10, maybe even longer. And you're here tonight because you're thinking, I just want to make sure that what I have still works. And that's a smart thing to do. The second group of people are those that have something in place, but they're not entirely sure how it works. And that happens more often than you think. People will sign these documents at some point in their lives, put them in a drawer, and never really revisit them. And the third group are people who've never planned before. And if that's you, that's perfectly okay. Everyone starts somewhere. And the purpose tonight, again, it's simply to help you understand so you can make good decisions going forward. By the end of this, you'll understand what's possible. You'll see the different strategies clearly, and you'll be able to look at your own life, your money, your family, your goals, and decide what makes sense for you. And not based on fear, not based on guesswork, but based on knowledge. And you're going to discover something even more important today. What you really want, it's not paperwork. You want planning. And there's a big difference. Paperwork, well, it's a stack of documents with your name on them. But planning is a strategy that makes things simple, smooth, and protected for the people that you love. You'll also see how you can control your future medical care. Who makes decisions if you can't? What kind of care you receive? What happens at the end of life? And how putting those choices in writing now gives you total control later, no matter what happens. And when this is done right, you don't just have documents, you have peace of mind. You know your family's protected, you know your wishes will be followed, and you know that your assets. Here's the truth that people don't often talk about. Dying always comes at a cost. And there's no way to avoid that. The only thing you get to decide is how that cost is taken care of or structured or dealt with. When someone dies, their family faces typically 3 categories of cost. The first one, it's emotional. I'm talking about grief, shock, confusion. And that part, well, it cannot be eliminated, but the chaos can absolutely be avoided with proper estate planning. The second cost is financial. I'm talking about tax consequences, legal fees, court costs. And the third is, well, legal related costs. I'm talking about really time delays, court proceedings, delays with probate, delays in transferring property, public filings. In the estate planning, it's not really about documents. Since documents are the tools, the estate planning is about controlling those costs for a better outcome for your loved ones. Next, I want to walk you through 5 real situations that I've personally seen over the years. And these are not hypotheticals. These are not rare exceptions. These are everyday families, good people who genuinely believed they had done everything right. They thought their estate plan was in place, they thought their wishes would be honored, and they thought their family would be protected. But when something actually happened, when it mattered most, their plan didn't work the way they expected. And in some of these situations, the consequences weren't just inconvenient, they were expensive, stressful, and in a few cases, completely life-changing for the people left behind. What I want you to take away from this section is not fear, but clarity. Because once you see how these breakdowns happen, once you understand where things tend to go wrong, you'll be in a much better position to make sure your plan actually works the way you intended to. So as we go through these, I want you to be thinking about your own situation and ask yourself, could this happen to my family? One of the biggest advantages of learning about estate planning this way is that you don't have to learn the lessons the hard way. Every situation that we're about to walk through, it comes from real court proceedings, real families, and real consequences. And over the years, I've seen how quickly things can go from we thought everything was handled to months, even years of stress, conflict, and unnecessary expense. It reminds me of something my mom used to tell me growing up. She said, you better learn from the classroom so you don't have to take the field trip. And what she meant was simple. It's a lot easier and a lot less painful to learn from someone else's experience than to live through it yourself. And that's exactly what we're doing here. Because once you see how these situations actually unfolded, and once you understand where things broke down, it becomes much easier to spot the gaps, avoid mistakes, and make sure you have a plan that does what it's supposed to when your family needs it most. The first situation involves something that catches a lot of people off guard, talking about a will that was never probated. I had a woman come to me after watching one of the webinars, and she wanted to put together a trust for her adult daughter. She'd been married to her husband for about 40 years, and they'd built a life together. They shared everything, and like most couples, she believed that when one of them passed, everything would naturally go to the other. They each had a will, and because of that, she truly believed that she didn't need to do anything else. She even said, "Why do I need to go through probate? He had a will, and everything went to me." But here's the part that she didn't realize. When her husband passed away, she never probated the will, not because she was trying to do anything wrong, but because she thought the will had already taken care of everything. So years went by, and the 4-year deadline to admit the will to probate in Texas passed. And that's where the problem began. Her husband had a child from a prior relationship, someone that they never really had any relationship with, someone they never really saw and never planned around. Because the will was never admitted to probate, the will no longer controlled, and Texas law stepped in and decided who inherits. And under Texas law, her husband's share of the home passed to his child from that prior relationship. So now, after 40 years of marriage, she didn't own her home outright. She owned it together with an adult child of her deceased husband, someone she had no relationship with and never expected to be financially tied to. And that's the key lesson here. It's not enough to have a will. It's not enough to have good intentions. And if the process isn't followed, the timing isn't right, the law fills in the gaps. And when it does, it doesn't care what you meant to happen. It just follows its own rules. The second situation involves something that sounds almost unbelievable, but I've seen it happen. Talking about a will that simply disappeared. And in this case, a father had a very clear plan. He wanted his estate divided 3 ways. 2 shares would go to his biological children, and a 3rd share would go to someone else. Someone he cared for deeply, but someone that he essentially treated like his own, even though there was never a formal adoption. And that was his intent. And that's what he put in his will. But after he passed away, the original, it couldn't be found. And here's where Texas law comes into play. Since the original will could not be located, the court presumes that it was intentionally revoked. Now, whether or not it actually happened or not, it doesn't matter. That's the legal presumption. So instead of following his plan, the estate defaulted to the Texas intestacy law, which meant that his 2 biological children inherited everything 50-50. And the 3rd person, the one he specifically chose to include, they received nothing. And here's the hard part. It wasn't an accident or bad luck. The reality is that the 2 adult children realized something. If the will wasn't probated, if it was never found, then they could inherit everything. So their story became, you know what? We never did find Dad's will. And just like that, his plan, his actual wishes, they were never carried out. Now, could have this been prevented? Absolutely. He could have filed his original will with the county clerk's office so it could never disappear. Or better yet, he could have set up a trust during his lifetime, something that doesn't rely on locating the original document after death, and something that can't be changed or ignored once he's gone. And that's a takeaway from this situation. It's not just about what you write down. It's about making sure that your plan is structured in a way that actually holds up, even if the people involved don't do what you expect them to do. The third situation involves something I see far too often, a DIY or do-it-yourself will that ended up costing a family years of their life. This was a very successful business owner, talking about over 7 figures a year, someone who clearly understood the value of good advice, and he regularly hired attorneys for his business deals, for contracts. But when it came time to his own estate plan, the one thing that would control everything he'd built, he decided to handle it himself. And on the surface, the document, it looked fine. It said what he wanted to happen. But here's the problem. The document didn't meet Texas legal requirements. And so when he passed away, that document, the one he was relying on, it couldn't be admitted to probate. And once that happened, everything unraveled. It wasn't a smooth transition. It wasn't clarity. It wasn't peace for the family. Instead, it was over 8 years of litigation, talking about fighting between his children and his surviving spouse, disputes over the assets, disagreement over control, and then instead of his estate doing what it was supposed to do, taking care of the people he loved, a significant portion of which he'd spent a lifetime building was spent instead fighting each other in court. And that's the lesson here. Estate planning isn't just about writing something down. It's not about having a document. It's about having a plan that actually works under the law, one that holds up when tested, and one that protects your family from exactly this kind of outcome. The fourth situation is one that surprises people because on the surface, this family did everything right. In fact, they did what many people consider to be the gold standard of estate planning. They created a living trust while they were living in California. They worked with an attorney, they'd set up the structure, they had the documents, everything looked exactly the way it should. But then life happened. They moved to Texas, and somewhere along the way, a critical step was missed. Some of their financial accounts were never retitled into the name of the trust. So when the husband passed away, those accounts were still in his individual name. And that changed everything. Because now, even though they had a trust, those assets didn't belong to the trust, which meant probate was required. And to make matters even worse, they're dealing with a California-based plan being sorted out through a Texas probate process. And this is the part most people don't realize. An unfunded trust doesn't do what it's supposed to do. The structure exists, the documents are there, but the protection, it's not. And that's the takeaway from this situation. Estate planning isn't just about having the right documents. It's about making sure those documents are actually connected to your assets. The fifth situation involves something that at first sounds like a mystery, but in reality, it's a very real risk. A man passed away overseas while on vacation, and as you can imagine, his family suddenly had to deal with everything, making arrangements, working through logistics, and ultimately bringing him back to the United States. And in order to do that, they needed to access his important documents. So his wife was still abroad, called his children from a previous relationship to ask for help in getting documents that were located in their safe. So they opened his safe, and inside were all the things that you would expect: legal papers, personal records, and his original will. And the will was clear. It left everything to his spouse and nothing to those kids. But sometime after that, the original will, well, it disappeared. Now, we can't say exactly what happened, but we can understand the incentives, because under Texas law, if the original will cannot be found, the court presumes that it was intentionally revoked. And if that happens, the estate doesn't follow the will, it follows Texas law, which in this case, it would benefit his kids, not his wife. So now, instead of a clear plan being carried out, the family is pulled into conflict. Then affidavits have to be gathered, witnesses have to be tracked down, and litigation begins, all in an effort to try to probate a copy of the will that once existed, but now can no longer be produced. And all of this could have been avoided, because with a properly structured trust, there's no reliance on a single original document after death. There's no opportunity for something to disappear. And that's the takeaway here. If your plan only works if the right documents show up at the right time, that's not a very strong plan. A well-designed estate plan should work even when things don't go perfectly. When families hear these stories, the reaction is often the same. They say something like, "That could easily happen to us." And they're right. These were not irresponsible families. Most of them believed they'd done the right thing, but small gaps in planning created enormous consequences. When you step back and take a look at all these situations together, a very clear pattern starts to emerge. None of these families were trying to avoid planning. In fact, most of them believed they'd done the right thing. They had documents, they had conversations, they had intentions. But what they didn't have was a plan that held up under real-world conditions. Because estate planning failures rarely come from something reckless or obvious, they come from small gaps. A missed deadline, a misplaced document, an unfunded trust, a technical requirement that wasn't quite satisfied. And those small gaps, they can lead to very large consequences. The kind of consequences that show up when it's too late to fix them. And that's why this matters. Good estate planning is not just about having documents in a folder or a safe. It's about making sure the entire system actually works when your family needs it, when emotions are high, when decisions have to be made, and when you're no longer there to explain what you meant. Because every situation we just walked through, every one of them, they were completely preventable. And not with more paperwork, but with better planning. So at this point, a very natural question starts to come up. What kind of estate plans actually prevent these kinds of problems? Because once you've seen how these situations play out in the real world, it becomes clear that not all plans are created equal. And when we step back and look at the big picture, most families end up following one of just three paths, whether they realize it or not. They either do nothing, they put together a will-based plan, or they build a trust-based plan. Those are really the three options. But here's the key. Each of those paths lead to very different outcomes, different levels of control, different levels of cost, complexity, and risk. And most importantly, very different experiences for the people that you've left behind. Let's start with the first option, doing nothing. If you never create an estate plan, the state of Texas already has one for you. The problem is that you didn't write it. Texas intestacy laws determine who inherits and how property is distributed, and the results are often very different from what families expect. One of the most common assumptions people make is this, that everything will automatically go to their spouse. And in Texas, this is not always how it works, because the law doesn't just look at your marriage, it looks at your entire family structure. So for example, if someone has children from a prior relationship, those children may have a legal right to inherit part of the certain assets, including the home. And now, instead of the surviving spouse owning everything outright, they could end up co-owning property with their spouse's children, which can create a very complicated and sometimes very uncomfortable ownership situation. Not because anyone intended for that to happen, but because that's how the law fills in the gaps when a clear plan isn't in place. This is something that we see often. A family comes into the office and says, our mom passed and we need to sell mom and dad's house. And the first question we ask is, when did your dad pass away? And there's usually a pause, and then they say, oh, about 10 years ago, and we never did anything. And right there, that's when everything changes, because we're not dealing with one estate, we're dealing with two. Two separate probate proceedings, one for dad that should have been handled years ago, and now one for mom. And the asset they're trying to sell, not just any asset, it's mom and dad's home. But because nothing was done when dad passed away, his ownership interest in that home was never properly transferred. So before the family can even begin to deal with mom's estate, they have to go back and try to fix dad's. And if that 4-year deadline to probate dad's will has passed, now we may not even be able to use his will at all, which means this. Instead of mom and dad deciding who inherits their home, the state of Texas steps in and decides for them. Because when there's no valid will admitted to probate, the law controls where everything goes. And the state's plan may look very different from what mom and dad actually intended. So what should have been a simple process, selling the family home, turns into multiple probate proceedings, delays, added costs, and sometimes unexpected ownership issues, all because something that should have been handled earlier wasn't. When there's no will in place, families don't just figure it out. They're forced into a legal process called an heirship proceedings. And this isn't simple. It involves court hearings, witnesses who have to testify about family history, attorneys preparing filings, and a judge that ultimately decides who the legal heirs are. In other words, instead of your family having clarity, they're having to prove in court who's entitled to what. And that process, it isn't just time-consuming, it's expensive. And it's not uncommon for an heirship proceeding to cost $7,000 or more per estate. Now think about what happens if both spouses pass away without a plan. Those costs don't go away, they double. 2 estates, 2 proceedings, 2 sets of legal fees. All of that is expensive and comes out of the very assets that you were hoping to leave behind to your family. So when people say, we'll get to it later, or we really don't need a plan, what they don't realize is doing nothing is not free. In many cases, it ends up being one of the most expensive choices a family can make. As opposed to doing nothing, the first real planning strategy is what I like to call the slide strategy. At its core is a will-based estate plan, and for many families, this is where the planning process begins. It's the most common starting point, the approach most people are familiar with, and often the first step people take when they decide it's time to get their affairs in order. Because at a minimum, every adult should have a basic plan in place, something that provides direction, creates clarity, and puts the right legal foundation under their wishes. This is where that foundation starts. So why do I call this a slide strategy? Because how everything transfers when something happens. I want you to picture this. It's like taking everything you own, your home, your bank accounts, your investments, your personal property, and you stack them all on top of a playground slide. And at the bottom of that slide, those are your beneficiaries, standing there with their hands open, waiting. And when you pass away, everything all goes at once. It all slides down. There's no staging, no timing, no conditions, no structure. It's one moment, one event, and everything transfers outright, all at once. So you have everything stacked at the top, and your beneficiaries are waiting at the bottom. And when death occurs, everything moves down immediately, all at once. Now, for some families, this is perfectly fine. There's a high level of trust, simple assets, and straightforward goals. But for many families, this is where problems start to show up. Because with this approach, there's very little control, very little protection, and very little structure that's built in. Let me give you an example. If an 18-year-old inherits $250,000, they don't inherit it in stages. They don't inherit it with guidance. They inherit it all at once, outright. It's their money. You can't say, use this for college. You can't say, this is for a home one day. You can't put guardrails around how it's used. And if a beneficiary is struggling, whether it's financial responsibility, outside influences, or even addiction, that money doesn't protect them. In many cases, it actually can make their situation worse. So the real question becomes this: are you comfortable with everything you've built transferring all at once with no built-in guardrails? For some families, the answer is yes, but it all depends on dynamics, your family dynamics. And for others, the lack of control, protection, and structure creates very real problems. Let's take a moment and clarify what a will actually does, and just as importantly, what a will doesn't do. A will is a powerful document. It allows you to decide who inherits your estate, who would raise your minor children, and who would serve as the executor to carry out your wishes. Those are important decisions, but here's what most people don't realize. A will does not control everything. In fact, many of the largest assets people own don't pass through a will at all. Things like retirement accounts, life insurance, and any account with a beneficiary designation. Those assets pass by contract, meaning they go directly to the named beneficiary automatically, regardless of what your will says. And here's the key point. Just like probate assets, there's no built-in control, conditions, or structures. You can't say, this only for certain purposes. You can't stagger distributions over time. You can't add guardrails. When that transfer happens, the beneficiary receives it outright. So whether the assets pass through a will or pass through a beneficiary designation, the end result is often the same. Everything transfers directly with no structure built in. A will-based plan typically includes several core documents: a last will and testament, a financial power of attorney, a healthcare power of attorney, a living will, and a HIPAA authorization. These are what we call foundational documents, and they matter because they give your family legal authority to step in and act when it's needed most. But here's the key point. The question is not whether you need these documents, you do. The real question is, are they enough? One of the most important things to understand about a will is this: a will does not avoid probate, it guides probate. In other words, the will is essentially a set of instructions to the probate court. The court still has to be involved, and the process is still supervised. This means filings, deadlines, attorneys, and court costs. And in many cases, the process can take months, if not years, depending on the complexity of the estate. Now, to be clear, for some families this works just fine. If the situation is simple, if everyone gets along, and if there's no need for added control or structure. The slide strategy, it can be entirely appropriate. But for other families, this approach can create unnecessary costs and delays and exposure, because instead of things happening efficiently and privately, they're now tied to a court process, one that takes time, costs money, and doesn't always operate on your family's timeline. So again, it comes back to fit. Not whether a will works, but whether it works in the way you need it to. Just for example, in Travis County today, even a simple uncontested probate where everyone agrees and gets along can cost around $5,000 in attorney's fees, and the process can still take 9 months or longer. Now, to be clear, this is still better than doing nothing, but it does mean court involvement, added costs, and delay that your family will have to navigate. The second planning strategy is what I call the bucket strategy. This approach uses a revocable living trust, and instead of stacking everything you own at the top of a slide, you place your assets inside of a bucket, a structure that holds everything together instead of letting it all move down at once. A trust-based estate plan builds on everything we just talked about in a will-based plan, but it adds something critical: structure. At the center of that structure is the trust. The trust is what holds your assets, and more importantly, what controls how they're managed and distributed. And here's the key. While you're alive, nothing changes in terms of control. You still make the decisions, you still manage your assets, you still stay fully in charge. The difference is, now there's a system in place that continues to work when you can't. This is where trust really starts to show its power, because when you pass away, your assets don't just move automatically. They're distributed according to your instructions, your intentions, and your plan. And inside that bucket, you can add something most plans are missing: rules, structure, and protection. So instead of saying each child gets a third, you can say they receive it in stages, or at certain ages, or tied to specific milestones. If a child has a disability, you can structure their inheritance so they don't lose critical government benefits like SSI or Medicaid. If a child is young, the trust can manage the money for them until they're mature enough to handle it. If a beneficiary is struggling with spending, the trust can control distributions and protect them from themselves. So instead of everything happening all at once, you move to intentional control, and that's the real difference. Trusts allow you to build in flexibility to protect assets from creditors, to add layers of protection in the event of divorce, to plan for special circumstances that your family may face. It's not just about who gets what, it's about how they get it, when they get it, and how well it's protected along the way. One of the biggest advantages of a trust is this: it allows you to avoid probate altogether. And that's not just a technical benefit, it's a very real practical impact for your family. Because with a properly funded trust, there's no need to open a probate case just to transfer assets. The trustee can step in immediately. They can manage assets, they can sell property, or begin distributions without waiting on court approval. This means no delays tied to the probate process, no waiting months for creditor claim periods to run, no additional filings just to move things forward. And if you own property in multiple states, you don't have to open multiple probates in each location. Everything flows through the trust. So instead of your family dealing with two separate tracks, the probate process and then the sale process, they can go straight into the sale process, saving time, reducing stress, and avoiding unnecessary costs along the way. And just as importantly, it all happens privately, without court oversight and without becoming part of the public record. One of the biggest misconceptions about a trust is that you're giving up control. In reality, it's the exact opposite. A revocable living trust is incredibly flexible while you're alive. You can change it, you can update it, you can amend the beneficiaries, you can replace trustees, you can add or remove assets. If your life changes, your plan can change with it. You can sell your home, buy a new one, move accounts, restructure things. As long as you're alive and competent, you remain fully in control. And here's what's important. For tax purposes, nothing really changes. It's still you. There's no new tax return, no new tax ID while you're alive. If you have a mortgage, the bank doesn't call it due. You still qualify for your homestead protection. They're just applied a little differently under the trust. Because legally, for most practical purposes, it's still you. The difference is now you're operating inside of a smarter structure, one where you're the trustee, you're the beneficiary, and you stay in control, with a system in place that continues to work when you no longer can. The most important step in making a trust actually work is funding. Funding simply means this: you take your assets and you properly place them into the trust. Because here's the reality: if the assets aren't in the trust can't control them and it can't protect them. An unfunded trust is like buying a safe and leaving all your valuables sitting on the floor next to it. The structure exists, but the protection doesn't. And that's where a lot of well-intentioned plans break down. Because it's not enough to have the trust document. You have to connect your assets to it so it actually does what it's designed to do. Now, one thing I want to clear up: this really isn't an either or between a will or a trust, because a trust-based estate plan still includes a will. It's just a different type of will. It's called a pour-over will, and it serves a very specific purpose. Think of it as a safety net. So if there's anything that didn't get transferred into your trust during your lifetime, let's say something you forgot or something new you acquired, the pour-over will directs those assets into your trust after death. It essentially catches anything left in your individual name and funnels it back into the trust where your plan is still carried out in full. Now, ideally, you never want to rely on it, because if you do, that means those assets may still have to go through probate just to get them into the trust. But it's there for a reason. It protects against the what-ifs. So instead of your plan breaking down because something was missed, you have built in a backup. And it helps make sure that everything still ends up where it's supposed to go. One of the biggest misconceptions about estate planning is that it's only about what happens when you pass away. But in many cases, the more immediate risk is this: what happens when you're still alive but unable to make decisions for yourself? Who steps in? Who has authority? Who manages your finances, your health care, your day-to-day affairs? Because without a clear plan in place, your family doesn't automatically have that authority. Instead, they may be forced into a guardianship proceedings, the court process having to have someone legally appointed to act on your behalf. And that process can be time-consuming, expensive, and incredibly stressful for the people that are trying to help you. So estate planning isn't just about transferring assets, it's also about maintaining control, making sure the right people can step in at the right time without having to have to go to court just to take care of you. I want to talk briefly about some documents you want to make sure that the right people can step in and understand what's going on and follow your wishes when you're unable to speak for yourself. Your medical power of attorney names who can make healthcare decisions for you. Your living will outlines your wishes for your end-of-life care. And your HIPAA authorization allows your loved ones to access your medical records when it matters most. When you step back and look at the big picture, most families end up choosing one of three paths. They either do nothing, they put a will-based plan in place, or they create a trust-based estate plan. And each of those choices comes with its own set of consequences. Now, this naturally leads to the most common question we get. Do I actually need a will, or do I really need a trust? And I'll give you the classic lawyer answer. It depends. But let me explain what this really means, because this is where a lot of people get stuck. Both a will and a trust are important tools, but they're not interchangeable. They're designed to do very different things. A will is essentially a set of instructions to the probate court. It tells the court who you want your assets to go to and who you want in charge, but the key word there is court. A trust, on the other hand, is designed to help your family avoid court altogether. It allows things to transfer privately, efficiently, and on your terms. So when someone comes into my office, what I'm really looking at is this. What are you trying to protect your family from, and what kind of outcome do you actually want for them? Because once we understand that, the right structure usually becomes pretty clear. For example, if your goal is to keep your family out of probate, avoid delays, and reduce legal fees, a trust almost always is the better option. If you own a home or any real estate, which for most people is the largest asset, that becomes a major factor. And if you own property in more than one state, a trust is almost always recommended. Because real estate going through probate is where we see some of the biggest headaches, delays, and really family conflict. If you have minor kids, minor children, this becomes even more important. Without a trust, we know everything passes to them at 18, not 25, not when they're mature, 18. And most people would agree that's probably not the best time for someone to receive a significant amount of money. A trust allows you to control that. We can stagger distributions, we can set guidelines, make sure the money actually helps them instead of hurting them. Another big one's privacy. A will becomes part of the public record. Anyone can see what you owned, what you owed, and who got what. A trust keeps it all private. It stays within your family. And then there's something people often overlook. A trust just doesn't plan for when you pass away. It also plans for when you're still here, but unable to make decisions. Whether that's an illness, an injury, or something unexpected, a properly structured trust allows someone to step in and manage things without court involvement. And finally, if there's any potential for family conflict, even just a concern, a trust gives you structure, clarity, and control, and it reduces the chance of disputes, making things much easier on the people you care about most. Now, I want to be clear. Every situation is different. There are absolute cases where a will-based plan makes sense, but what I can tell you from experience is this. Most people underestimate how quickly their situation crosses the line into where trust becomes a better option. And if even a few of these points are hitting home for you, avoiding court, protecting your kids, keeping things private, or reducing stress or conflict for your family, then there's a very good chance that a trust-based estate plan is the right fit for what you're looking to accomplish. Every estate plan has a cost. The real question is, when do you want to pay it? With a will-based plan, the cost is usually lower up front, but higher later, through probate, delays, legal fees that your family have to handle. With the trust-based plan, there's more work to be done up front, but it's designed to reduce those future costs, delays, and headaches. So it's not about avoiding cost. It's about choosing when and how it shows up. At the end of the day, the real decision comes down to control. Do you want the state of Texas deciding how things unfold? Do you want a plan that still requires court involvement? Or do you want a plan that keeps things private, structured, and on your terms? Here's what I want you to know. Estate planning, it isn't really about you. It's about the people you love. Without a plan, families are going to inherit confusion, stress, and difficult decisions. But with a plan, they're going to inherit clarity, direction, and protection. This is one of the last and most meaningful ways that you can take care of them. It's truly an act of love. And in doing so, you get to decide what kind of legacy you want to leave behind. At this point, you've learned a lot. You understand the risks, you understand options, and you already have a sense of what kind of plan feels right for you. And because you've taken the time to go through this webinar, you're coming in more informed than most people, which makes the process easier for us. It's more focused, and often it's much faster. So if you'd like help evaluating your situation, here's how we would do that. We would walk you through three things: your family, your assets, and your goals. And from there, we would determine together what plan makes the most sense for you. Now, normally, we charge $500 for a consultation. But because you've watched this webinar and you've taken the time to educate yourself, we want to waive that fee and offer you a complimentary estate planning consultation. In the first step, it's simple. We start with a brief 15-minute phone call. We talk through your situation and make sure that it makes sense for us to move forward. Now, if you'd like to take advantage of that complimentary consultation, the key is to act now and get that first step scheduled. You don't have to have the call right now, but you do have to go ahead and get it on the calendar. And just so you know, the complimentary consultation, it's something that we only offer to those people who take action now during the presentation. If you wait until later or come back tomorrow, the consultation fee goes back to the standard $500. So take a moment now and lock in a time that works for you. Here's how you can do it. You can click the link on your screen now, or you can call the office at 512-601-5843, or you can send us an email to ep@jasonenglish.net, ep@jasonenglish.net, and just pick an option that's easiest for you and get that 15-minute call scheduled now. Thank you again for taking the time to be here with me. I know this isn't always the easiest topic to think about, but it is an important one. And at the end of the day, estate planning, it isn't really about documents. It's about taking care of the people that you love. Because the decisions you make now can make a very difficult time a little clearer, a little easier for the people that you leave behind. My hope is that this gave you some clarity and helped you better understand your options and made you feel more confident about taking the next step in a way that makes sense for your family. Thank you.